Okay, thank you for joining once again. We're going to be continuing with our series, Flow of Persons. We are talking about mental illness as a factor affecting status. And now we're going to be talking about lucid interval up until the end, hopefully up until the end of this series on mental illness. Okay? So lucid interval, what does that mean? What is that? Okay, so a lucid interval is a temporary period where a mentally ill person regains mental clarity, right? So during this period, the person may be able to perform valid legal acts, right? For example, an elderly person with dementia may have moments of confusion and moments of clarity, right? If they sign a will during a confused period, the will may be invalid. But if they sign it during a clear moment where they understand their property, their family, and the effect of the will, it may be valid, right? This is very important for exams, for those that have exams coming up, right? So don't say that once mentally ill, always incapable. This is wrong, right? The law looks at the person's mental state at the exact moment of the legal act, right? So, in order for you to gain a better understanding, we're going to discuss the case of Lange versus Lange. It's a 1945 case. This is a leading case. For mental illness. So this case is important because it confirms the legal test determining whether mental illness affects capacity. The central issue in the case was whether a person had sufficient mental capacity to perform a legal act. So the court had to consider whether a person understood what they were doing and whether they appreciated the consequences of the act. So the principle from Lange versus Lange is that a legal act will only be valid if the person had sufficient mental capacity at the time of the act. So the person must understand the nature and consequences of the transaction. So if the person doesn't understand the act, the person doesn't understand, the act cannot stand as a valid juristic act, right? So in simple terms, we can say that the court is saying it is not enough that the person physically signed a document. The law may also ask whether their mind was capable of understanding the document. Okay, so a signature without understanding may not create a valid legal act. So imagine a person signs a contract selling their farm. If they understand that they are selling the farm, understand who the buyer is, understand the price, and understand that they will lose ownership, and then they have capacity. But if they sign while believing that the document is a birthday card, then they do not understand the nature of the act, then this kind of concern, that's the kind of concern that the Lange versus Lange case dealt with, right? So the case is therefore used to support the rule that mental capacity is not about physical ability to sign. It is about the mental ability to understand, right? And then so that will take us to a very important topic, curatorship. Okay. Um, so when a person is unable to manage their own affairs because of mental illness, the court may appoint a curator, right? So a curator is a person appointed to assist or represent someone who cannot properly act for themselves. And what we need to understand is that there are many different types of curators. We have a curator boni, that's the one that manages the person's property and financial affairs. For example, if a mentally ill person owns a house, receives rental income, and has bank accounts, the curator boni manages those financial matters, right? And then we've got a curator persona. A curator persona deals with the person's personal welfare, and this may include decisions about care, accommodation, and personal needs, right? And then lastly, we've got a curator ad litem, which represents the person in legal proceedings. For example, if a mental ill person is involved in a court case but cannot represent their own interest, a curator ad litem may be appointed for that particular case, right? So, for example, let's say imagine a person's mental illness is so severe that they cannot pay their accounts, they can't manage their bank cards, they can't protect their property or understand legal documents. The court may appoint someone trustworthy to handle those matters. That person does not become the owner of the property; they manage it for the benefit of the mentally ill person, right? And then we know that mental illness will have obviously an effect on litigation. So when mental illnesses it affects a person's capacity to litigate. So first let's take just a step back and just to do a refresher on what the capacity to litigate is. So that means that's the ability to appear in court as a party and to conduct legal proceedings, right? So if a person cannot understand litigation because of mental illness, they cannot properly sue or defend a case on their own. They may need a curator ad litem, right? For example, if Mary is sued for breach of contract, but she does not understand what the court papers are, what a defense is or what consequences may follow, it will be unfair to expect her to defend herself alone. The court may require representation through a curator, right? Okay. It can also affect mental illness, can also affect a person's ability to hold certain offices. Some positions require the mental ability, such as judgment and responsibility. And then if a person cannot understand the duties attached to that office, the law may restrict them. A person who cannot manage their own affairs may not be suitable to hold an office that requires managing someone else's affairs, right? Such as a trustee, a director, or an executor, depending on the specific legal rules that are applicable in that particular scenario. And also, as we move along, we know that mental illness can affect criminal liability, right? So, in criminal law, a person is generally only guilty if they had the necessary mental capacity and fault, right? So, if mental illness prevents a person from understanding what they're doing or from appreciating that it is wrong, they may not be criminally responsible in the ordinary sense, right? So, for example, if a person breaks a window while fully aware that they're damaging someone's property, they may be criminally liable. But if because of severe mental illness, they genuinely do not understand reality or the wrongfulness of the act, their criminal capacity may be affected, right? So just to keep it, keeping it simple. So criminal liability requires more than physical conduct. The law also asks whether the person had the mental ability to be blamed. Okay. Now that we've covered criminal liability, let's talk about delictual liability. Okay, so delictual liability, it deals with the civil wrongs such as damaging someone's property, injuring someone. So mental illness may affect delictual liability where the intention or the negligence is required, right? So if a person cannot understand the wrongfulness or the consequences of their conduct, it may be difficult to prove intention or negligence. For example, if Peter intentionally throws a stone at someone's car, he may be delictually liable. But if Peter is suffering from severe mental illness and does not understand what he's doing, the law may find that he lacked the necessary fault, right? And again, the key question is not merely that was Peter mentally ill. The key question here is, did the illness prevent him from understanding his conduct and its consequences at the time, right? Now that we have dealt with that, let's quickly move into the administration under the Mental Health Act, right? The Mental Health Care Act, right? So apart from curatorship, the law also allows for administration under the Mental Health Care Act. An administrator may be appointed to manage the property of a mentally ill person in certain circumstances, right? So the difference is that curatorship is usually a high court process and it can be expensive and formal. you know Administration under the Mental Health Care Act is intended to be a more accessible statutory mechanism for managing the property of a mentally ill person. So it can be seen as an alternative to curatorship. It's a cheaper alternative and then a more accessible statutory mechanism, you know. So for exam purposes, for the ones that are writing exams, or for knowledge purposes, you must always remember this distinction. Curatorship is broader and it's court-based. Administration is statutory and is often focused on managing property, right? So I'm just going to help you to understand or how to answer problem questions in the next video. So I will help you how to answer questions step by step in the next video. And thank you so much for joining, and do not go away. The next video will be on how to answer a problem question that you may be faced with during your exams. Thank you.